All rise. The Court of Appeals, Division 1 is now in session.
Hello, please be seated. This is Arizona Court of Appeals, Division 1, cause number CAIC 140045, Fayette, AC, Colorado versus Rickard. For your information, there's only two of us up here. Judge Thema, who is our presiding and wanted to be here today, had a family emergency, and so he is not participating in the oral argument, but he is going to listen to the oral argument upon his return. So, anyway, so that's why there's only two of us. These proceedings are being recorded, and so as you begin your argument, if you will, when you approach the podium, if you'll please state your name and who you are representing. Each side will have 20 minutes to present your argument, and appellant, you may reserve a portion of your time for rebuttal. If you will tell us how much time you want for rebuttal, we will try not to ask too many questions into that time. We have read the briefs. We've discussed the case at conference this morning, so we are aware of the facts and the issues that are before us. The clock on the podium will tell you how much time you have, and that includes your rebuttal time as well for appellant. So with that in mind, as I indicated, the proceedings are being recorded both audially and visually, and hopefully in a couple of weeks you'll be able to see yourself on YouTube for your 20 minutes of fame. So with that in mind, you may proceed.
May it please the court, counsel. My name is Lisa Lamont. I'm representing the petitioners in this case, Fayette Air Conditioning and Colorado Casualty Insurance. The issue is whether the decedent Martin Rickard's unusual activity of relocating pillars for a non-customer occurred in the course of his employment. The legal issue, this is an in the course of employment case only. Petitioners.
Okay, so help me understand.
Sure.
You're not addressing arising out of.
No, it's quite obvious that Mr. Rickard's injuries arose from the use of the crane that day. The only real question is whether that crane use was a work activity.
Okay, thank you.
And in fact, within the in course of analysis, I think it can be narrowed even further. In the course of refers to the time, place, and circumstances. There's no question that Mr. Rickard was within the confines of his normal workday. He was on the clock. He was also in a place where he could be expected to be. He was on a job site, although the job task that he had been sent there to do had ended, and he was to be packing up to return to the office. The real issue is the circumstance part of that, whether the activity causing his injury was work-related. The respondents have argued in the answering brief that this is an easy question, that Mr. Rickard was engaged in the exact type of work that Fayette entrusted him to every day at the time of his injury. But respondent has described that over broadly as operating a crane to move items that were too heavy and large to move otherwise. That's a broad overgeneralization. Fayette Air Conditioning is an air conditioning contractor. They needed cranes to move air conditioning units, which weighed several tons. There's a big difference between moving air conditioning units and moving house pillars. Air conditioning units are the essence of the business. Moving house pillars are not.
Counsel, there was some discussion in the record, I think, that these type of favors, I think they were characterized as favors for potential clients or clients, was done in the past. But is there any indication of what those favors might entail, i.e. moving wood, bricks, a pallet of bricks? Is there anything in the record at all to reflect how those other favors were carried out?
No, there isn't, Your Honor. Mr. Mark Fayette, the owner of the company, did indicate that he was asked to do favors all the time. I can only assume that lots of people have heavy things they need moved. Most of those were for customers, but non-customers would ask from time to time as well. But there was no specific information as exactly what was asked of them in the past.
And did he say that he performed those favors?
Mr. Fayette indicated that at times he did agree to do favors, but the important point there is that he's the owner of the company. It's his decision on whether his company is going to assume the risk to take on any of these extra tasks outside the contract. And that's really one of the essences of the argument.
Well, before you move on,
Sure.
I just wanted to ask you one other thing. It appears that the Mrs. Rickard indicated that Mr. Fayette said, if I had been there, I'd have done the same thing. Did Mr. Fayette agree to that? I mean, did he acknowledge that? Did he?
I know Mrs. Rickard did testify to that. I honestly don't recall whether or not Mr. Fayette confirmed that.
Okay.
I don't consider that, assuming it is true, to be admission against interest. I believe Mrs. Rickard testified that he said that to her at the hospital, where her husband was still there battling what ended up to be fatal injuries. Those are words of comfort, I believe, he provided. The Ricards were his friends. They socialized with them all the time. I don't believe words of comfort are admission against interest, especially in light of what the undisputed evidence was at hearing in terms of the policies of Fayette Air Conditioning, in terms of doing any extra work outside of the contract or favors.
Okay.
As I indicated, time and place are met, but circumstance is the critical factor. The dependable messenger case notes that just because an injury occurs during work hours and on work premises is not enough to put it in the course of employment. The injury-producing activity, here Mr. Rickard's specific use of the crane, has to be, according to the dependable messenger court, entwined with the employment and have some connotations of benefit to the employer. And those are really the two strong reasons why petitioners believe that Mr. Rickard's activity at the time of his injury was not in the course of employment. First, because the activity that he was engaged in was not approved or authorized by the employer. And secondly, because it did not benefit the employer. I'd first like to address, I'm sorry?
Go ahead.
And not approved or authorized. I mean, I'll admit to you right now that I have not read all the case law in this area, because there's quite a few cases. But having looked at a good number, it seems like not approved or authorized doesn't really matter sometimes. Or does it? Just because something's not explicitly authorized, that's not necessarily definitive, isn't it? Can't there be implied authorization?
There can be, express or implied. I don't believe there's either here. It's not necessarily express authorization. Certainly in some of the cases cited by respondents, the Delgado case, the court found that there was implicit authorization for this. I don't believe any such inference can be made from the record in this case.
And you're suggesting it was in fact prohibited?
Yes.
Why?
Because Mr. Fayette made clear that it was his policy and that the employees, including Mr. Rickard, knew this. If anyone, a customer, asked them to do work outside the contract or to do a favor, they were to contact him. He would assess the situation and make the determination of whether additional work would be done at additional cost or whether they would agree to do the favor. He said employees called back to do that all the time. Mr. Rickard had done that in the past, and he had never had authority or assumed authority to take on this kind of risk on behalf of the company. He did not have that authority.
In that conversation, I guess the way I read the ALJ's ruling is the ALJ was reading that testimony as applying to sort of a change order analysis. Like if the customer said, hey, we'd like to do, we hired you to do X, but we need you to do Y now. We need to change that. So they would necessarily need to be a callback, sort of a change order, if you will, approval. But how would that apply to a non-customer? Or is there any evidence that they did apply that to a non-customer?
There is, and Your Honor, I can read you the specific testimony of Mr. Fayette, a very short quote. It's from page 17 of the hearing transcript. This was Mr. Fayette's testimony. He said, people ask favors all the time. It doesn't mean we do them. Sometimes we do. They'll, meaning employees, call back and ask, and it's up to me to decide. Some of this stuff is not safe, and some is. So Mr. Fayette made clear that even with favors to customers or non-customers, the policy was the employees called back because it was ultimately his decision, and his decision alone as to whether or not this additional work would be done, whether for payment or as a favor.
But you disagree with me that the ALJ seemed to not agree with your position on that?
I think he made an inference that's not supported by the record.
Okay.
Right. All right. The lack of express or implicit approval. I guess my point is, Your Honor, that there was no implicit policy, certainly no express permission to do this task, and there was no implicit policy to perform all unscheduled favors for non-customers. The testimony instead supports the policy that all employees, including Reichard, would call back if they were asked to do something and obtain approval from Mr. Fayette if it was to be done. And it's this factor that distinguishes this case from the two cited by respondents in their brief in support of their position. The first was Delgado, which I just mentioned. Delgado was an employee who was injured on the clock on the employer's premises while using the employer's air pump to inflate a tire in his own personal car. There, the Court of Appeals found that in the course of employment, but they based it on the fact that the personal use of the air pump was condoned or implicitly approved by the employer, and it was not, or it was an insubstantial deviation from work. Here, our position is that there was no approval, there was no implicit approval, and this was a substantial deviation from Mr. Reichard's work. He was there to use the crane to remove and reset an air conditioning unit, not to move house pillars. That's completely removed from the task that he was sent there to do.
How do you draw the line between insubstantial and substantial deviations? Let's say that there was 3 or 4 bricks that were just happened to be up on the roof, just for argument's sake, or brick or lumber pieces, and the homeowner is standing there watching and says, "Hey, could you, Mr. Rickard, could you do me a quick favor? Could you walk over and clean those off for me before you guys leave?" He does that. He walks over. Something happens, unfortunately, slips and falls. Is that it? Is that a substantial deviation?
Well, I think it's still a deviation. I mean, substantial and insubstantial is a matter of degrees. I think the pillar removal here is extremely far removed. The situation you've described maybe isn't quite as removed, but still is not the task he was sent there to do, which is remove an air conditioning unit with a crane.
I mean, okay, I want to back up to sort of, let's go back just a few minutes. I should have asked this before, but what case do you think is the best case to guide our analysis as far as the test? Like, what is the current test in Arizona for in the courts? Is it Royal? Is it Finnegan? Is it?
That's a good question. I'm not sure it's entirely clear. Respondents have argued it's totality of the circumstances, but
That's more Finnegan.
That's more of a Finnegan case. In most of these compensability determinations, in my experience in reviewing all the case law, on a case-by-case basis, it's done somewhat differently. The test, in terms of, depending on the facts of the case, what test is applied. I don't have a problem with totality of circumstances. The circumstances include benefit to the employer and approval, which I think are the crucial factors here. The other issues, yes, it was in the time, and
He was being paid for this, and it's undisputed.
he was on the
right?
clock.
He was on the clock.
Yes. All right. And I wanted to point out as well a difference between Finnegan versus Industrial Commission that was cited. The Finnegan case was the employee who was injured at his work in auto garage after hours using the employer's equipment to work on a coworker's car. That was held to be in the course of employment, but there the undisputed evidence showed that the employee was there with the express permission of the employer. He had the express permission to use the equipment for that reason and to stay after hours to do this. So that type of express permission or even implicit permission is not even close to what's present in this case. The respondents also cited some but-for language, kind of a but-for test from the Finnegan case, saying that but for the employment relationship, the employee would not have been able to assist his co-employee in repairing his car or be on the employer's equipment or premises. But that but-for analysis is misplaced here. The court and Finnegan used the but-for analysis to analyze the fact that that was an after-hours case. The time component was not there. He was not on the clock, not being paid outside of the normal workday. That but-for analysis was used to rationalize why he would be in the course of employment despite not being paid for the time. So that is not relevant here. We believe the Gonzalez case is really the most on point to what happened here. Gonzalez is an employee who was injured while using his employer's heavy equipment on lunch hour to pick up wood for a personal benefit. This court there conceded there was some benefit to the employer in that activity because it did help clean up the premises, but was persuaded by the fact that the employer had not approved of this activity. The court noted that even though that employee was where he reasonably could be expected to be, the employer had no knowledge of what he was doing and did not consent to his use of their heavy equipment for that purpose. That's equally true here. And again, petitioners have argued that not only was this not approved or consented, but it was expressly prohibited. Favors and additional work were not to be done without the express approval of Mark Fayette, the owner of the company. I wanted to speak briefly about the second point, about there being no benefit to the employer.
Well, essentially.
Yeah, I think that's a stretch and non-existent, where the third party, the homeowner, wasn't even a customer of Fayette Air Conditioning, and they in fact had declined to become a customer the day before.
But they could be next year. I mean, the next year.
Well, I think it's kind of a stretch to think that this homeowner would want anything to do with Fayette Air Conditioning in the future after what had happened. They asked for a favor. It didn't get done. This horrible accident happened on their property. They were drug into a police investigation and an insurance investigation. I think the more reasonable inference is these homeowners won't want anything to do with Fayette Air Conditioning in the future and wouldn't want to be reminded of this event.
But that's after the accident. If they had not done it, if he had said no, I think you could make that inference. But if they had done it, and they did do it, and they or attempted to do it, and had done it successfully, I think, don't you think there was potential for some goodwill there, especially in a small community where you don't have a lot of different companies to choose from, and certainly would have, in my mind, I would have thought of them the next time I needed an air conditioner.
Well, again, I think that's too speculative. The Gomer case, which speaks to this issue, was actually a stronger case because in Gomer, the employee acted for the benefit of the third person who was actually a customer of the employer, and there's no such relationship established here, and they found any goodwill that might flow to the employer from the third party or the employee doing a favor for the customer was too speculative. I think there needs to be, goodwill is kind of an interesting concept, but I think it's really speculative to say. There's no way really to know whether that would have benefited in the future. They declined to become a customer and purchase a new air conditioning unit the day before. They were not a customer. There's no reason to think they would become a customer in the future.
And if they would have agreed, hypothetically, what if they said, yes, we agree to become yes, we'd like that would make a difference if they said, yes, we'd like you to put a new air conditioning system in?
I think it's a stronger case. I think there's a more direct link to any potential goodwill if they had entered into a customer relationship. This was his customer.
Which then brings up the question: how important is this potential benefit to the employer amongst all the factors you've mentioned? How important is this one?
I think it's very important. The Gomer court said that when an employee acts for the benefit of a third person, the injury sustained from that conduct is not in the course of employment unless it also benefits the employer. So there has to be benefit shown. And I just think it's too speculative here.
How does a guy changing his tire at 4 a.m. at the garage benefit the employer?
I think
that's Delgado, right?
That's Delgado. I don't remember. I'm sure it's probably some type of employee morale.
Electricity. I don't know. I mean, honestly, I sometimes you struggle reconciling these fact patterns. I mean, I do at least.
No, I understand. I do as well. I'm running low on time. I'm going to reserve the rest for rebuttal. Thank you.
Thank you.
May it please the court, counsel, Bruce Rosenberg from Taylor & Associates on behalf of the respondent employee Martin Rickard and his wife Shelda. The real basic position of the respondents in this case is that we're overthinking the scope of the work that Mr. Rickard was doing at the time of this accident. When it comes right down to it, he's a crane operator. He's one of 2 crane operators in this company, the only other one being the owner of the company. What he was doing at the time this accident that led to his death was operating the crane. A couple of things that Your Honors mentioned that I did want to point out. In his findings, the administrative law judge specifically found that Mr. Fayette did do favors for non-customers or customers from time to time when he was operating the crane. He really didn't make an effort, if you will, to relate this callback policy to the favors that were done. In fact, in their request for a review, the petitioners told the judge that Mr. Fayette acknowledged, and he did in his testimony, that it would be unusual, since this was not their customer, since it didn't have to do with a change order, since it didn't have to do with some additional work that was going to be done under a contract. And this is the way he described the favors. He said, I do favors for guys all the time. You know, they ask all the time. I don't do it, but people ask.
Sorry, counsel, what page are you on?
I'm looking at page 26 of the transcript.
Okay.
And then he confirms that Mr. Rickard is a 10-year employee. We had already established that Mr. Rickard was basically the right-hand man of Mr. Fayette. He's in charge in the field. And he is the only other crane operator. And then where we came up with benefit to the employer was from the employer. On this same page of the transcript, he was asked, when you do favors for people all the time, and sometimes you do that for them, and there's some PR benefit to the company for doing that, right? And when he understands public relations is what we're talking about, he says, sure, especially in a town the size of Lake Havasu. And he says, right, where everybody knows everybody. And he said, that's right. So certainly there is some benefit to the employer, and again, that comes directly from the employer. It's the same with the favors, and whether these favors are beyond the scope of what the crane operators did on a daily basis.
Counsel, you could, I guess I could foresee a possible abuse of that as from a policy standpoint. I mean, how far could you go on the goodwill? Could it go beyond even use of the crane? Like, can you help me in other ways? The customer says, hey, I need some help moving the washer and dryer. You know, could you just give me a hand for a few minutes? And then it results in a back injury or something. I mean, where do you draw the line between, you know, this is my job, I'm out here on the job, and I'm going to promote goodwill by, you know, having a drink on the back porch with the homeowner and you know, and relaxing and building some rapport and trying to drum up clientele. I don't think that was the decedent's job. So help me understand, where would you draw a line on goodwill or benefit to the employer?
Well, first of all, if you're looking at the totality of the circumstances and you're going through this checklist that the administrative law judge went through when he made these findings, that is one of several. There are cases that say if the only circumstance that you have is some benefit to the employer, but you have nothing else. You're not on the clock. You're not using the employer's equipment. You don't have the permission, implied or express, of the employer. If you're missing everything else, that goodwill is not going to be enough. On the other hand, you develop some practice, and it's going to be decided on a case-by-case and employer-by-employer basis. And there's going to be that same analysis in every case where an employee...
So there could be no goodwill or next to nothing of goodwill, and you're saying that doesn't necessarily end the inquiry.
That's correct. I think the Prosser case that was cited in the briefs is one of those where the court said You can have very, very little goodwill, but if it's there and it's identifiable, it's one of the factors to consider. And again, in this case, that factor comes directly from Mr. Fayette himself, from the owner of the company. And then the other answer to the question, Your Honor, is the cases tell us how far you go with this, or at least what the framework is. I'm looking at the Finnegan case, and they're quoting from the Michigan Supreme Court in the Nemeth case, where they say that the course of employment is more comprehensive than the assigned work. That's why it's our position that we're overthinking this. We're overanalyzing this. There's no evidence anywhere in the record that the only thing this crane was ever used for was air conditioning units. No one said anything like that. There was never a question about, well, have you ever lifted bricks? Have you ever lifted poles? Have you ever lifted a car for somebody? And you know, you can hypothetically imagine cases like that where you really are going beyond what you do on a normal day-to-day basis. But again, if the framework is, what does this person do? Is this in the course of employment such that it's incidental to, or a reasonable person in that employee's position could be expected to do that for that person at that time with that equipment under all of the circumstances. That's
For
the
instance, if you said, I'm having a problem, or I've got a flat tire, and I need help changing it, and the jack falls. I mean, is that tied to employment? I mean, you're saying that would tend to stretch that was within the duties of his employment.
That would tend to stretch. And if you're talking about a crane operator helping somebody work on a car, you're talking about a little different animal than a crane operator doing a favor for somebody operating his crane. And the cases speak to that. You know, whether, for instance, in the Galmer case that the petitioners cite to, what the court really found in that case is that everything the employee was doing was purely personal. So not only was there no goodwill, he wasn't using any of the employer's equipment, he wasn't getting paid at the time that the accident happened. So when you go through, again, all of those elements of the totality of the circumstances, then that's why the Galmer case was decided the way that it was, and it makes some sense. He's doing a favor flying a plane for somebody that there may be a customer relationship with his employer, but it really was just a favor. And I think the court also focused on the fact that he was real excited about it because he enjoyed flying and he really wanted to fly this plane. So when this person approached him, would you fly it from, Nogales to Mexico City? He said, oh, absolutely, that sounds great. And then he's taking it for a test run before the trip, and that's when the accident happens. So you're missing all of the other totality of the circumstances issues before you even get to was there some goodwill. And what the court really decided was that was for purely personal benefit. And then in the Delgado case, the court actually pointed out, blowing up your tire with an air pump that your employer lets you use really isn't part of your job for that employer. But is it incident there too? Again, that's the way that the cases speak of.
And with counsel, was that at the shop? Was that the employer's site?
That's correct.
Yeah.
That's correct. The air pump. Go ahead.
Well, I was wondering if you're aware. Did the court find any goodwill there? Was it, or even address that? I mean, I guess it would be hard to find what the benefit would have been to that employer. I'm looking at page 665
of P. Second in the Delgado, this is the dependable messenger case. And they speak there to goodwill also and talk about there not being that nexus to your work. I was looking for the site in Delgado where the court says use of the air hose was incidental to his employment. And, you said yourself, Judge, the cases when they go on a case-by-case basis like this are all over the board. So here you have one where the employees are, coming to work for this employer, doing something that has nothing to do with, their vehicles or their tires or any of that. And the court still found that but for that employment relationship, again, they get back to that but for, he would not have been in that place at that time using his employer's equipment with his employer's permission. They talk about an activity that connotes a benefit to the employer. Quite frankly, I think that's a way of the court saying we really didn't find any benefit to the owner other than the fact that he's making it convenient for his employees so that they don't have to go to the gas station to fill up their tire. So when the courts analyze course of employment first and then they later on get to goodwill and say, well, there may or may not be any, they're simply giving it less emphasis than the other aspects. And if you take a look at paragraph 9 of the administrative law judge's decision, he goes through all of these elements of the totality of circumstances as they are established in Finnegan and the cases before and after Finnegan and the cases cited in there. And he goes through each one saying that it wasn't prohibited, that there was no personal enjoyment to him or no personal purpose in his doing this favor for the homeowner. And fairly, I think, the administrative law judge said it is fair to infer, again based upon the totality of the evidence, that the employer may have or could have received some goodwill from the favor in which Mr. Rickard was engaged when the accident occurred. Again, I think that's the judge saying, Mr. Rickard, or Mr. Fayette, the owner of the company, admitted that there was some goodwill, but it's not really what we're going to focus on, and it's not what we ought to be focusing on under the facts of this case. It's there, and Mr. Fayette said it's there, but it's not what we're going to be focusing on. The other case that talks about the course of employment and how far you go with a deviation, whether it's substantial and insubstantial, is the Rodriguez case. That's a case that quotes from, it's actually a Missouri case. No, sorry. That is the Court of Appeals case that quotes from the Supreme Court's Goodyear case, which was really the first of the cases to talk about course of employment. And in Goodyear they said, if it's the rational consequence of, or if it had its origin in, the employment relationship itself. So that's what we're looking for. In this case, again, the administrative law judge appropriately found that Mr. Rickard was where he was supposed to be, where he was expected to be. He was on the clock. He was using the employer's equipment. He was using it in a way that it was designed. In other words, he wasn't using a crane to dig a hole. He was using it in the way that it should have been used. And one point I did want to come back to also is Judge's point about Mr. Fayette saying, I would have done the same thing. What the transcript shows is that that conversation took place in the car on the way to Las Vegas after Mr. Rickard was air evac'd there. They didn't know what his condition was at that point. They knew it was serious, and that's why he had to go by helicopter to the metro area from Lake Havasu City. But this was conversation in the car. She specifically testified to that. Mr. Fayette heard that testimony and offered nothing in response. In fact, the administrative law judge found that fact important enough that he set it out as a specific paragraph in his findings and award where he said that this was essentially uncontradicted and unimpeached. So we have these favors that Mr. Fayette would have done. This favor, he would have done the same thing according to that testimony. That is really the extent, I think, of any explanation or definition of our position that I have, unless the court has additional questions for me.
No, thank you, Mr. Rosenberg.
With respect to what Mr. Fayette would have done in this circumstance, what his testimony was, is that had Mr. Rickard called him and explained the favor that was asked, he would have gone out to the job site to evaluate it. The office was 2 minutes from the homeowner. Mr. Rickard knew that Fayette was there. He had just spoken to him briefly because Mr. Rickard had called to let him know that the job was delayed. They were packing up and coming back to the office. So he was available. He was 2 miles away. He said if he had been called, he would have done, as the owner of the company, what he does in these situations, gone out to the homeowner, evaluated the situation, and made the decision of whether this was safe and whether they would have done it for pay or as a favor. But he was not given that opportunity. The bottom line is that Mr. Rickard's activity of relocating pillars was not the work that he was charged with doing that day. Yes, he was using the crane, but that was not the purpose that he was sent there to do. That was not his work activity. Mr. Fayette did not give permission for this activity. He did not condone it. Mr. Rickard had never before taken on this type of task without getting permission first. He had no authority to assume this type of risk on behalf of the company. Fayette was the only one who could authorize it. The employer, here the owner of a small company, has to have the right to define the scope of the employment and what activities are authorized and what are not.
But doesn't he need to convey, if he or she wants to do that, don't they have an obligation to put that in writing, tell the employees? I mean, I know you can do A, but you can't do B. I mean, in other words, a strict policy. We don't deviate from the job. No ifs, ands, or buts. We don't do it. I mean, unless you get specific permission. I mean, if that were in writing, obviously your position would be strengthened, wouldn't it not?
If it was in writing, sure, but I think it's strengthened by the fact that this was the past policy. This is what had happened in the past. When this happened, employees knew. They called and asked Mr. Fayette whether or not this could be done. That was his undisputed testimony. So it was the established policy, whether it was in writing or not. There's clearly no direct benefit to the employer for this. Fayette received no money as consideration for doing this favor. And again, it's petitioner's position that any indirect benefit is too speculative here. This was a very unfortunate accident, and while tragic, it is not the type that the workers' comp statutes are meant to cover, which is why petitioners are respectfully asking that this court set aside the decision of the Industrial Commission. Thank you.
Thank you.
Thank you. We will take the matter under advisement and issue a ruling in due course. Thank you very much, both of you, for your argument. It was very interesting and helpful, so thank you very much. We are adjourned.